beyond that, the prosecutor, and I think you would appreciate this, opened the trial by claiming that Hauptmann propped a ladder against the house, climbed up to the second floor, took the sleeping child from his crib, stuffed him in a burlap bag, and then as he was exiting out the window, dropped the child 2 stories to the mud below, cracking his skull and killing him instantly. That was the claim. During the trial, the defense said, why didn't the child cry out? So at closing argument, the prosecutor changed his theory and said instead, oh no, what really happened is he was killed in his crib, that Hauptmann had a chisel in his hand and crushed the kid's skull and strangled him, both of which were totally contrary to the medical reports of the examiner of the corpse. There was no blood found by the police on the crib, in the nursery, on the ground. The medical examiner testified in a prior proceeding that it was impossible for the skull fractures to be caused by a 2-story fall into mud. And there was no blood found in the burlap bag that they had in court that they said was used to transport the child. And the police had, and the prosecutor had, an 18-page forensic report by Squibb Laboratories, which is now Bristol Myers Squibb, that also proved that there was no blood on the child's T-shirts that the corpse was wearing, on the sleeping suit that had been separately returned that the child wore that night, or on the ground in the leaves or the dirt where the corpse was found. No blood anywhere. And yet the corpse, when it was found, was largely skeletal.
So those arguments of the prosecutor in their closing argument were not based on any facts that were testified to or brought in during the trial?
No, they were not. They found a chisel in the yard. The chisel, which he alleged was the alternate idea for the murder, and yet the chisel had no blood on it either. And they knew, the police knew also, and the prosecutor knew that it wasn't Hauptmann's chisel. It had somebody else's initials on it. They implicated to the jury that Hauptmann had it must have been Hauptmann's because they said that one of his chisels was missing when they went to his garage in September 1934, but they knew that it wasn't a match.